morning to all of you on Party Sustainability Time. You folks on the West Coast, I know some of you, I saw you in the chat box, so you've been here since 5:30 in the morning. I want to say good afternoon to the rest of the country, because for some of you, it's getting pretty late. And so just want to welcome you all to this policy as prevention, code enforcement, proactive rental inspections, or as I call it, the boots on the ground and suits in the courtroom edition of this summit. I want to thank all the organizers and the attendees and all of the panelists. I am Larry Brooks. I do work now for the National Center for Healthy Housing, but I was formerly the director of Alameda County Healthy Homes and Child-Led Poisoning Prevention in Oakland, California for many years. And in a prior life, I was the chief of code enforcement in the California state capital of Sacramento, doing housing code enforcement first for the environmental health department, the planning community development department, and even spent some time doing code enforcement in the police department of all places. So I have some stories I could tell you guys about that, but we're not going to hear them today because we've got this excellent panel that I want to introduce you to. And in fact, what I will do is I'm going to just let you know who they are, and then they're going to introduce themselves to you because they've got a lot to say, and I've done some research on them and their organizations, and they've done some great work. And so I want you to hear from them rather than hear old war stories from me. So we got Amanda Settlemeyer, Executive Director, Turtle Creek Valley Council of Government. We also have with us Brooke Christie, equal. Ooh, oh, I thought I heard somebody. Okay, Brooke Christie, Equal Justice Works Fellow, Fair Shake Environmental Legal Services in Pittsburgh. And we have Megan Benford, Staff Attorney, Public Interest Law Center. So how about what we do is we'll just go in that order and we'll have you all introduce yourselves and spend a few minutes telling the audience a little bit about you and the work you do. And you may end up answering some of their questions and some of mine before we can ask them. So Amanda, let's go with you.
Well, hello. Thank you for having me today. Appreciate being here and humbled by all of the information that I've learned. It is definitely a learning process for me. So thank you to everyone. I work for the Turtle Creek Valley Council of Governments. And for those of you who are not familiar with what COGS are, we are a voluntary organization. We're quasi-governmental, and we encourage intergovernmental cooperation amongst our members and within the broader region. And so with that, if you could change slides, please. Just an overview of how we sort of approach code enforcement, and just an acknowledgement that problem properties really do pose a hazard to communities and drain resources. We recognize that strategic code enforcement is the first line of defense in communities, and that we really need to become more strategic and use tools that are at our disposal in the state of Pennsylvania, at least. And that technology is essential for this work. And just to say, that code enforcement is so important to the health, safety, and welfare of communities and the people that live in them. Next slide, please. And so just a little history on some of the work that we've been doing. Back in 2012, my partner at our sister COG, Still Rivers Council of Governments, and I started talking about this issue pertaining to blight, which we felt so pervasively in our region. This is a picture of our combined footprint in Allegheny County. And so we did a cost of blight study, a financial impact of blight study, because at the same time, the state legislature was considering legislation around enabling land banks. And we felt that before we asked our communities to invest in a tool, that we really needed to get a better handle on what blight meant in our communities. And so what we learned is that 60% of all blight in Allegheny County outside of the city of Pittsburgh was concentrated in our footprint, that it was costing us around $250 million a year, and that if you lived within a 150-foot radius within a blighted property, that your property, even if it was in pristine condition, was devalued anywhere from 17 upwards of 25%, depending on the market value of your community. And so these talking points really gave us a foundation to start having meaningful conversations with our elected officials. One other thing I wanted to point out, I'm sorry, on that slide, which was kind of a surprise to us, is that blight impacted every single one of our communities. We did this on a broader scale of Allegheny County as a whole too, and there was not one community that was not impacted by blight to one degree or other. Okay, thank you. Next slide. And just to put this in a little bit more context, this is the slide that was done from the most recent market value analysis in Allegheny County. And if I could direct your attention to the slide on the right, affordability at 50% of the county median income, that yellow area to the bottom right-hand side of Allegheny County is that's us. That's Turtle Creek Valley COG and Still Rivers COG. And what this really essentially says is that people who make 50% or less of the county median income, which is probably around 35,000 a year, are concentrated in that yellow area. And the brown area represents the other places in the county where those folks cannot live. They can't rent there, they can't own there. It is out of reach. And so what that means is that these communities that have these concentrations of poverty have less earned income tax, have less real estate tax to be able to mitigate the issues in their communities. Next slide, please. And so at least in our neck of the woods, code enforcement was always thought as sort of like the poor stepchild of policing. There really wasn't a lot of emphasis. It was the grass police. People didn't really understand the importance of the work of code enforcement officers. And so there was a huge learning curve and education that had to take place and is still continuing to take place about why code enforcement, property maintenance code enforcement, in this case specifically, is so important. So we recognize that there are so many hazards that are posed by unmaintained buildings, including lead. Next slide, please. And there is a growing body of evidence that suggests that if you live in a proximity to blighted property, that there are all kinds of negative health outcomes, including the ones listed here. Next slide. And so strategic code enforcement really is a tool it's one tool in the toolbox to help start mitigating some of these issues in our communities. And maybe most important from my perspective is providing critical protection for renters. Next slide, please. So we feel like the work that we've been doing in this space really hits at that blue box in the middle, the neighborhood built environment, because turns out that having healthy, safe, well-functioning communities is complicated. And it takes a lot of partners and people coming together all at once to sort of make an impact in communities. And so out of the financial impact of blight study, there were two outcomes. One was the creation of what we call the Tri-Cog Land Bank. And that organization repurposes vacant tax delinquent properties and works to get them into productive reuse. And the other outcome was the importance of code enforcement. And when we thought about code enforcement, we had so much to learn. So we worked through our partners at the Center for Community Progress and the Pennsylvania Housing Alliance to learn everything that we could about good strategic code enforcement. And time and again, we heard that technology was really important, especially in places that had limited resources. Next slide, please. And so what we learned is that there wasn't really good technology out there to help us keep our code enforcement officers organized around the flood of information that they have to keep track of. And there was no tool that helped us best use uh, I'm thinking specifically of Act 90 in Pennsylvania, which allows for permit denial and other places when there are guilty citations anywhere in the state. So our intent and at the outset was to create a tool for towns who otherwise couldn't afford one. And I should mention that I missed Bob Gradick's presentation. I'm gonna have to go back and watch it. But Bob, who presented earlier today, was instrumental in helping us to start think about a tool and what a good quality tool could and should look at. And we still partner with Bob today, thankfully. So what we did was create a web-based relational database, and with a real focus on providing our code enforcement officers a tool to stay organized and present information if it has to go to court in a way that district judges like to see it. Next slide, please. And so what sort of sets this tool apart from other tools, as far as I can tell, is that most code enforcement tools are parcel based. They're map based or based on parcels. This one is both person and parcel based, and that means we're able to connect people with properties. But there are two sides of the system. There's a permit file, a permit side to the system, and there's a code enforcement case side. And there's a whole lot of thought and effort into how to create the system that provided a mechanism to keep code enforcement officers on track for follow-up and to organize these large workloads. And also to demonstrate the value to decision makers who often don't understand why they're making the investment in code enforcement. Next slide, please. And so as we started to develop the system, we started to build in more and more functionality. I'm not going to do it justice in this presentation. There is a robust functionality in the system, but one of the important things that we learned was the ability to flag properties for certain hazards. And so you can see the high lead exposure on this particular slide. Also wanted to point out that we do partner with Parcels and At, which is a link on our on our page there. Okay, next slide, please. And again, linking persons and inspections to certificate status, and also being able to, because we, at least in our neck of the woods, we have a lot of issues with LLCs that come in and buy up properties, and sometimes it's hard to know who owns them or who's affiliated with them. So being able to correlate people with properties has been really, really important. But our tool also gets down to the unit level. And right now we're building out a rental registry, rental inspection portion of the system, which we feel is the last piece. So we have our property maintenance side, our case side, we have our inspection side, and now this rental registry side, we think will complete the circle. Next slide, please. And so to do inspections, we actually ended up having to create an app, which is available on Google Play and the Apple Store, because there were pockets in our footprint that did not connect. There was no connectivity. So we created an app that code enforcement officers can go in and build checklists, which standardizes how they look at properties, which I love. And so they can take their checklist into a property regardless of connectivity and conduct their inspection. And when they come back into connectivity, all of that information is automatically uploaded into the system. Next slide, please. And this is just our list of functionality, which, obviously not going to read, but just to make the case that we really have put a lot of time, effort, and taxpayer dollars into creating this system. And we have 12 communities that are actively using it. And so we're just sort of on the beginning side of this. We feel like we are stronger together, and the more communities that use it, the more effective it's going to become because of that cross municipal communication aspect of it. And so we're looking to grow the system and bring on new members. Next slide, please. And this slide is really just to make the case that these issues are so complicated. And so we have really come to learn over the years that partnerships and strategic partners in particular are super important when trying to mitigate issues like blight that are just so multifaceted. And so we've developed partnerships, obviously, with code enforcement can identify issues or abandonment, which then could be fed to the Tri-Cog Land Bank, which then maybe could partner with City of Bridges Community Land Trust or Rebuilding Together Pittsburgh and try and bridge some of the gaps that exist in the system and why properties tend to languish sometimes. So that is what we have been working on, and I'm looking forward to hearing our other panelists. Thanks.
Excellent. Thank you. Wow. I'm sorry Dr. Buncher wasn't here to see this because I know he spoke earlier and said he had to go and see patients, but I think this kind of hits at the heart of what he was talking about in terms of a more comprehensive preventative approach to lead poisoning prevention. So this is beautiful. Um, I really do believe that we do have to look at it holistically in terms of universal blood lead testing and also in terms of things like code enforcement, proactive rental inspection programs. Um, because even with universal blood lead testing, it's really not fair to use children as our lead check swabs. I think that what you guys are doing here is wonderful. Um, I said that this is going to be the boots on the ground and the suits in the courtroom edition of the summit. So now we heard a little bit about boots on the ground, and I'm going to get back to the boots on the ground stuff later. But first, we need to hear from our suits in the courtroom. So let's go next to Brooke Christie.
Hi all, my name is Brooke, she, her pronouns. I am a attorney with Fair Shake Environmental Legal Services. Just a little bit about me. I do come to this with community organizing experience, and that is what led me to pursue legal education. Um, I joined the nonprofit Fair Shake because they are structured around community-centered legal counsel. So really, how we operate is we assist in whatever needs environmentally that our community needs, which brings us to lead exposure. We do operate in 3 states, Ohio, Pennsylvania, and West Virginia. And, throughout these discussions, you'll hear about how lead really is handled differently on local levels. And so managing lead exposure for our nonprofit law firm across 3 jurisdictions is very difficult. So I was brought onto the team to try to assess how some of these differences are managed across our jurisdiction. And throughout my 2 years with Fair Shake, I have helped several families. So what do we do within every landlord? Sorry, I keep getting calls. Within every landlord tenant lease, there's an implied warranty of habitability. What that essentially means is that every single unit must be safe and sanitary. We often look to housing codes for this definition of what that means, but it extends beyond them as well. This implied warranty habitability requires that repairs must be completed in a reasonable time and affords landlords a maximum of 30 days to do so. But that term reasonable is really where arguments often arise. And this varies based on the severity. Landlords, I mean, you could think about how landlords and a single mom will determine what reasonable is for lead exposure, right? There will be big differences there on when you're coming in to fix the paint, what is a reasonable time. So what is possible for, holding landlords accountable for lead exposure versus how it typically plays out? Well, it is possible to have landlords held accountable through complaints or the court system. Typically, complaints will be lodged with like the Allegheny County Health Department or your local code enforcement. Depending on severity, it might even be the EPA. Those respective agencies can respond with notices and fines. They also can result in lawsuits for damages, including if a child is exposed, you can hold them liable for personal injury claims. You also could be held liable for relocation costs for tenants. You have a lease, you have a duty to maintain a safe and healthy housing. So if you're unable to do that, you can be held liable and forced to pay for costs of relocation, as well as reimburse that tenant for any legal costs that they expensed when holding you accountable to that terms and condition. So that's what's possible. However, that is typically not how it plays out due to different power imbalances, like the fact that tenants often have difficulty getting legal counsel, as well as the whole system relies on the tenant lodging a complaint. And so a landlord could conveniently choose not to renew the lease. They could file for eviction when you withhold rent. So what often happens is that really bad actors tend to get away with it. And we do have studies that show, especially within Allegheny County, that it is often landlords, the same landlords reoffending consistently. I've even experienced this. I have represented 3 mothers that had lead exposure in the unit, but their child was not yet exposed. So that was good news. But unfortunately, there's very little services for that proactive mom, right? The health department is typically only notified after a child is exposed. The tenant can lodge complaints. But again, lodging a complaint, there's a risk that the landlord could retaliate with eviction, especially because mothers that are going through this tend to be withholding rent because they're, taking time off work to try to fix the unit. They're taking time off work to get their child tested. And so that's why we need proactive policy changes. The law is very reactive and often requires our children to be the canary in the coal mine for a lot of services, such as free legal counsel, such as free inspections to determine where the lead exposure is coming from. Such proactive protections could include rental registries. A lot of Pittsburgh folks on this call will know we have legal barriers to that specifically. But that is what the goal is to have that proactive protection. So what can we do in the meantime? We have several calls to action, such as number 1, passing an anti-retaliation ordinance. Retaliation of a tenant that lodges complaints is already illegal. However, again, what is real versus what plays out in the court system is very different. It is almost impossible for a tenant to prove within court that the landlord was retaliatory because of the amount of burden of proof that they have to bear. So passing an anti-retaliation ordinance would simply shift that burden of proof onto the landlord. It's their duty to get into the mind of them and why they chose to take action against a tenant. They should prove why they took that action. And so it does give a more fair trial. Similarly, to better protect tenants that lodge complaints, we should, as a state, seal evictions for tenants that have had their cases dismissed or settled outside of court. Last year, the Housing Alliance of Pennsylvania released a study that showed 80% of surveyed landlords said they would not rent to a tenant with a past eviction case, regardless of what happened in that case, such as the tenant prevailing on the merits or it being dismissed. Just as a again, a personal experience of that. One of the mothers that I represented, the unit was so bad that there was a hole in the wall of the unit where you could physically reach your hand outside. This is a very clear violation of building codes. She had had difficulties managing communications with the landlord, and so she opted to terminate the lease and leave the unit. Despite that, the landlord retaliated by filing for eviction, which was completely improper. She did prevail, with counsel in the court. It was dismissed, but that will forever be on her record. And so she will forever have difficulty renting until that eviction is sealed. And right now, that is a very difficult process. Most evictions cannot be sealed. So state policy changes would, help with that. There is a House representative named Smith Wade L., who's been leading that charge. And Governor Shapiro has also called for sealing evictions when the case is dismissed or the tenant prevails. But right now, that's not the reality. And so that is unfortunately how cases typically play out in the court system. And that's all I have.
All righty. Thank you so much, Brooke. Incredible work you do. I uh, think you've got a slide presentation you're going to show us now, or or no, Megan has a slide presentation.
That's
Great.
me, yes.
Okay. We're only 20 minutes into the hour and we have 45 minutes, so we're doing great on time here. Megan, I'm gonna let you go ahead with your slide presentation. I think you might have even thrown a question in the chat. Um, and I'm encouraging other people to also throw questions in the chat, because when Megan gets done, then we're going to drop the PowerPoint slide screen and we're just going to go round robin. I have some questions that I want to ask. I hope that the attendees, you have questions you want to ask, because you get to go first, because I'm kind of like Captain America and Marvel the Avengers. I can talk about this all day. Uh, but oh, I should say, for Brooke and Megan, my attorneys always throw out that disclaimer. I am an attorney, but I'm not necessarily your attorney. So I can talk about this, but I can't give you legal advice. So I'm going to throw that disclaimer in before you start. So go right ahead.
Thank you, Larry. Yeah, that's right. Everything I say here is not legal advice. It's just my interpretation of what I'll be talking about today, which is the lead paint disclosure law in Philadelphia. So my name is Megan Binford. I'm a staff attorney at the Public Interest Law Center here in Philadelphia. I am newer here. I just started in April, and I'm a staff attorney working on housing and environmental justice. But one of the first cases that I started with was a case of a tenant who was dealing with lead in their property. And I'm going to talk about that a little later, but sort of in the way that like a baby bird imprints on their mother, I have sort of imprinted on lead as an issue that I think is so important and so interesting. And I don't know how, in my prior life before April, I wasn't really aware of how terrible the consequences of lead poisoning are and how prevalent it is, especially here in Philadelphia, where all our housing stock is fairly old. So I'm going to talk to you today about our lead ordinance and how it works in practice. And I'm just want to say that I'm really grateful to be here among people who've worked on this issue for so long and have so much expertise. I have really, done a deep dive on the law, and I'm hoping that I can do it justice when I explain it to you here today. So with that, if we could go to the first slide. Okay, so before I get into the different parts of the ordinance, I just want to point out that there was a recent amendment that changed the law. So previous versions of the law applied only to homes where children under 6 years of age resided, because obviously those are the people that are being targeted by the law to protect, because they are the individuals who can be most damaged by lead poisoning. However, that led to obvious issues with enforcement because, you know, landlords and property owners were sort of escaping liability by saying, they weren't aware that anyone under the age of 6 resided in the property. Oftentimes a child isn't on the lease, and it just became too hard to prove that the landlord knew about the presence of a child. So starting in 2020, there was sort of a ramp up where the new version became applicable to different zip codes over the course of a couple of years, and now it is fully implemented as to every property that's rented here in Philadelphia. Okay, so next slide. All right, so the ordinance has several interrelated pieces that make it effective. And the first is an affirmative obligation to inspect and disclose. So every property available for rent that is built before 1978, which again is the vast majority of properties in Philadelphia, must have a lead safe or lead free certificate. And there is a rebuttable presumption in the law that all rental properties are built before this time. So the law casts a wide net, obviously, if your property is not as easy to prove as an owner. And so the purpose of this is, to sort of respond to what Brooke was saying, is to make the law proactive, not reactive. So as I'll talk about when we get into enforcement, and as I'm sure most of you already know, what's so effective about an ordinance is that the city is able to reach a huge number of properties before they become an issue and fix the lead problems with those properties before they affect anybody. I think, Larry, you said that it's not appropriate to have children be like the lead testing kit, essentially, to light up with lead poisoning to indicate that there's a problem. So this ordinance tries to get at that. So the certificate, which I'm going to show you in a minute, has a lot of different components. And when it is properly completed, it means that the property was tested and found to be free of deteriorated paint or lead dust above EPA acceptable levels. And there are a few requirements for the certificate to be valid. The first is that it has to contain the signature of a certified lead inspector, which presumably means that that is a person who has gone in accordance with their training and EPA standards, properly tested the unit. And it has to be accompanied by lab results that show the lead dust levels. Okay, so if you could flip to the next slide. All right, so here is an actual certificate. As you'll notice, it has an area for the signature of the licensed lead inspector. And that is obviously a really important component of this. And I will get into the rest on the next slide. So another requirement is that the certificate has to be provided to the tenant and signed by the tenant. And so what the law is trying to get at here is making sure that the tenant is aware of the presence of lead in the property, though at the time of certification, it is certified to be below a dangerous level. That way a tenant can know to keep an eye on things. So unfortunately, there's not really much case law about the ordinance yet at the appellate level. And there was recently a bad case in our Superior Court where an individual brought a case seeking cancellation of all prior rent paid, where there actually was not even a lead danger alleged. And the landlord had undisputedly provided the certificate, but where the tenant had not signed the certificate. So obviously the facts there are not great. And it's my opinion that a case like that shouldn't be brought. But the finding was that in those circumstances, essentially the landlord has done what they're supposed to do. They provided the certificate, and just because there's no signature on it doesn't mean that it was invalid. So we're hoping that a case like that isn't used against tenants in cases where they actually have been lead poisoned and the landlord has not fulfilled their duties under the statute, because it does unequivocally say that the certificate should be signed by the tenant. So this is something that the Law Center is really wanting to get into, because we are an organization that does like impact-based litigation. We'd like to help put teeth into the statute with a case at the appellate level, and we're just looking for the right one. So the landlord is also required to file the certificate with the health department so that the city can know who is in compliance. And the city, we actually did a right to know request to get the city to release all the properties that have properly certified. In practice, there's no penalty for not certifying, even though the city does have lists of properties that are available for rent and that are not certified. So there actually has to be an enforcement action brought. It's not brought automatically just because there's no rental certification. However, without the lead safe certificate, a landlord or owner is not eligible to get a rental certificate. So they cannot legally rent a home. And as you'll notice, I put asterisk around the word legally because, as I'm sure everybody knows, not every property is rented legally. So I have a lot of friends who do direct service and do eviction, and that is obviously a defense to eviction. So if you're trying to evict someone from a home that doesn't have these types of certifications, you know, there is a remedy for the tenant in that case. But these type of homes that are not rented legally obviously escape the lead certification's affirmative efforts to make sure that these homes are safe. Okay, next slide. So the obligation to repair is another interrelated part of the statute, and it's really where the rubber hits the road. So in my experience, unfortunately, as Larry addressed before, people often find out that there's lead in their apartment when a child who resides there tests positive for an elevated blood lead level. And that sets into motion a mechanism for alerting the city, the tenant, and the owner and or landlord, which I'll address in a couple slides. There are other ways that someone can detect the presence of lead in their home. They might notice chipped or peeling paint because, as I said before, a certification requires that there is no deteriorated paint. So just noticing something like that can trigger an obligation on the part of the landlord or owner to repair if notice is provided. So like I said, once the landlord is noticed, which is another sort of hitch, they have to promptly inspect and correct. So the ideal scenario is that the landlord does that once the tenant lets the landlord know that there's an issue, either an elevated blood level or other indicator that there's lead in the property. The landlord would hopefully then take steps to repair it. But if not, that can form the basis of an enforcement action by the city or a private lawsuit. So, as I said before, a stumbling block here is notice. And anyone who is a lawyer will understand that this is a big part of a requirement in seeking a remedy, is that the person is aware of a problem. So a lot of landlords will say, even after an elevated blood lead level result, which requires that the city inform the landlord, or even, despite obvious evidence to the contrary, that they were not aware of a lead hazard. And that is just another way that owners and landlords, not all of them, obviously the bad actors, can try to escape liability under this ordinance. All right, next slide. Okay. So there are penalties for noncompliance here. The city can fine an owner of a home that doesn't comply with this ordinance $2,000 a day. Again, the city is not going out and targeting any property that doesn't turn in a lead safe certificate. This only comes to their attention in the case where enforcement is really needed. In addition to a city enforcement mechanism, there's a private right of action for tenants, which is really important, and a good stick to the carrot. So remedies for the tenant include an injunction, damages for harm caused and exemplary damages, attorney's fees, and a refund of rent paid while the certificate was not valid. So like I mentioned before, because a landlord's not supposed to rent without a certificate, they can't charge rent. And this is something that my friends in eviction court often win on because, they're a bad actor landlord might be trying to evict someone when in reality they shouldn't have even been renting the place. Okay, so I want to get a little into city enforcement. So I talked a little about this before. When a child tests positive for an elevated blood lead level, this is a priority case for the city. So there's a program called the Lead in Healthy Homes program that is within the Department of Public Health, and they are supposed to be notified by the child's doctor. They, in turn, have somebody go out and inspect the property where the child resides. And there's also somebody to provide education to the tenant about how they can protect the child while they are still at the property. If, and this like most often does happen, if there is a positive test for lead in either the paint or the dust, they inform the landlord and then allow a little time for the landlord to remediate before they do a follow-up test. Within 30 days, they are supposed to follow up, and if there's not been any remediation on part of the landlord, they will file a complaint. They, the city, will file a complaint against the landlord in lead court. Then we're in, the sphere of court again, where the judge can impose fines, where the landlord doesn't remediate or will not remediate. And I should mention that the Lead and Healthy Homes program can also help provide funding for abatement if a landlord is having issues because of finances. And so they will take information from both the tenant and the landlord and use that to do, I believe, a grant. And I'm going to address, how this plays out with practice in just a minute. But first, I do want to say something positive, which is on the next slide. So the results of the ordinance have been really fantastic. So I'm just comparing from 2011 to 2022 here, and I got these statistics from the health department. But the ordinance has been around for even longer, and the drop in elevated blood lead levels has been even more precipitous. So the most recent results in 2022 show that only 6% of the city's 3-year-olds have elevated blood levels, compared with about 10 years ago, there were 30%. So the affirmative obligation on the front end is doing a lot of work here. I actually looked through the Excel sheet of homes for rent that have provided lead safe certificates to the city, and I counted about 93,000. I didn't actually count every cell. I just just sorted them in order and looked at the list. And Pew estimates at about 288,000 units total for rent. So I can't really do a great comparison there because not all the units were built before 1978, but you can see that it is working. A lot of units are being certified as lead safe. Okay, so next slide. Okay, don't have anything written there, but so basically, I just want to talk to you about how I've seen this play out. So at the Law Center, we don't really handle individual cases. We want to, like I said before, try to help put teeth into the law by bringing a big case or by trying to get helpful interpretations of the law on appeal. So I have, however, worked on a few cases, and these are all cases that arose from elevated blood level test and were months down the line where the problem had not yet been repaired. So in these cases, the city had already been involved in enforcement, but the landlord had not abated. So in practice, like Brooke spoke about, we know that court cases move slowly. And so in these instances, notices weren't properly issued by the city. Legal process had to properly be served. Amanda, you mentioned that like sometimes you have to chase down the owner of an LLC, which is not obvious, as I have figured by trying to do it myself. The court provides the landlord with multiple chances to remediate. I was in lead court just the other day. I wanted to go see it for myself for the first time, which is difficult because it only happens once a month, which is another issue. So when I was there, I saw a case that was back on its like 6th listing. They're like, we initially issued this complaint back in April of 2024. And I'm like, wow, this is so horrible. And they have, the tenant and the landlord at the bar of court finally filling out the paperwork for the grant funding. So it's obvious that the court system and the health department are overwhelmed in these circumstances. And I think that the point that I take from these cases is that litigation and enforcement are good deterrents, and they are good as a last line of defense. But the true value of an ordinance is ensuring compliance on the front end when it comes to preventing lead poisoning. So yeah, I saw a lot of questions going up in the chat. I'm happy to answer those to the extent that I can. I think I saw something asking about whether I can attribute the results to solely the lead ordinance. I that is not my area of expertise. I was simply pulling these numbers from the Philadelphia Health Department website. So I'm sure that there are a variety of factors that sort of play into this, but I think that the ordinance certainly had a hand.
Okay, as I said, we're going to go round robin here in a moment, give some people some time to throw some questions into the chat box. I think Brooke was already answering some questions in the chat box. I was responding to, I think, a question from Donald about decrease of the available rental housing stock as a result of intensive code enforcement. And as I said, in the cities and counties that I've worked in where they introduced proactive inspection programs, that was typically the knee-jerk reaction of the landlord community because they knew that the program needed to be funded and it was probably going to be funded through an annual fee on rental housing. And so, yeah, people actually got up at the rental expo about a year ago in the Bay Area here and threatened some of the elected officials with saying, I'm going to get rid of my rental property here in California, and I'm going to go rent property in Texas. Uh, they make those threats, and it doesn't happen. I know when I investigated this with some other cities like Cleveland and Rochester, Rochester's my rock stars. When they went proactive, yeah, some landlords try to push back. But what I have seen over the years is once you can convince the elected officials to pass an ordinance to do some type of proactive work, the landlords pretty much fall in line because it actually ends up in the long run helping them because the responsible landlords really aren't going to get dinged, but it's the landlords that give them the bad name of slumlords. That's why a lot of landlords here want to be called rental housing providers. They don't want to be called landlords anymore because they know they'll be connected with the bad landlords. But in those places where they've done these programs, it's actually helped increase their property values and improved communities. So I see a question here from Leah. Are there any lead ordinances that you are aware that do cite fine landlords if their lead safe certificate is not submitted in a timely manner or at all? Any of the attorneys want to jump in on that? Because that's kind of related to what I want to talk to them about is when do you use the hammer?
That is not something that happens in Philadelphia. I think that, code enforcement or L&I here is just very overwhelmed and they're trying to put out fires where they can. So I think that they would say they don't really have time to chase down a code violation where there's no actual injury.
One thing that the Public Interest Law Center did that I was really, really impressed with was when they put in the requirement for the certifications. The, the rental units had to be certified lead safe. That was supposed to be public information. And for a time, it was not. And the Public Interest Law Center actually went to court and pushed that issue to where now that information is public. And I was really impressed by that when I went and looked you up and looked up the Public Interest Law Center. Good code enforcement officer. I'm supposed to do that. But that's the other reason I'm so excited to talk to this group because I looked you all up in your organizations and was really impressed with what you do. Let's see, Brooke did say in the chat there are some that are supposed to, including Cleveland. However, they typically only pursue if the landlord is a particularly bad actor. Daniel says, importantly, different cities have various approaches to enforcing lead enforcement along civil in Rochester or criminal Cleveland lines. And either of those pathways comes with a whole host of complications. Thank you all for that. Let's see. Like I said, I'm like Steve Rogers. I can do this all day, Captain America. So while we're waiting on other questions, I want to jump in with some questions of my own for the panel. So, Amanda, with the Turtle Creek Valley Council of Governments, you have the occupancy permit, which is required for transfer of ownership of property in or when there is a tenant that changes. And you work with the Western Pennsylvania Regional Data Center using what is called Code N, as in Nancy, Code Enforcement App. I learned that this morning from the presenters. Um, Dr. Buncher mentioned his work with virtual inspections of homes with lead poisoned families. And I'm wondering, have you all considered a proactive inspection program that might include virtual inspections? And also, can you talk a little bit about the certificate of occupancy versus a proactive rental inspection program? And yeah, what is your partnership like with the public health to measure the impact of the work that you guys are doing on child lead poisoning rates?
So I see sort of occupancy inspection and rental inspection. We use the International Property Maintenance Code in most of our towns, in addition to whatever local ordinances they may have also adopted to conduct those inspections. I think the beauty of code enforce is that code enforcement officers can create checklists that standardizes those inspections across the board, no matter what, property. It kind of takes the bias out of inspections. And so I think in terms of what I'm trying to figure that out, like what is our role in mitigating lead? I've heard some of our previous panel talk about dust wipes, and we've had those conversations here. I understand that there's a cost associated with the dust wipes. I'm not clear on how that moves the needle, and instead of just mitigating, like if you see chipping, peeling paint, just using the International Property Maintenance Code to have that remedy, then I guess I'm still trying to understand how we can intervene in a meaningful way in places where resources are really limited. Yeah, so I'm here probably learning more than I'm contributing.
Hey, it's baseball World Series time, and I think you just pitched one right across the plate for our legal folks to knock out of the park here. In terms of lead sampling evidence from a lab, I mean, Rochester, New York, my rock stars, that's what their code enforcement officers do. They're certified lead sampling techs, and I wish more code enforcement officers would do that. Brooke, how does that help you in court?
So typically we do rely on code enforcement inspections for court proceedings. It is really vital that those are provided because often tenants do not have the money to pay for their own inspection. So that is a great process. I will say there's gaps. For example, if you don't have a kid in the household or if your kid is over the age of 6, you typically don't get those free inspections. So we have had some unique things going on in the region, such as a nonprofit called Clash is working with the EPA to obtain an XRF machine as well as get properly certified so they can provide that to community members for free. So there will be like some unique solutions like that that will be needed. Families can, um, buy testing kits to indicate things, but that won't be admissible in court, but it can be helpful just for that initial complaint to your landlord and negotiations with them. I do want to point out that Megan asked me earlier, how did the families know that they were being exposed to lead? They did not have a formal XRF in the beginning. It was typically just a visual inspection, but the units were so bad. I mean, Amanda showed that picture earlier of lead hazards with like things falling off the ceiling. I mean, that's the kind of condition that these tenants were living in. It was just undeniable that there would be lead hazards in the unit, to which, one family took themselves out of the situation. Landlord wanted to hold them accountable, uh, and we were able to pay for that XRF and then force them to reimburse the cost. But at the time of leaving, of course, they did not have that information. So, Yeah, I mean, code enforcement is the primary way, but we still have some gaps and some community needs there as well.
Let's see. Leah asked the question, what if the municipal leaders like the voting council include a lot of landlords? How can you change their will to enact an ordinance? Anyone want to tell some war stories along those lines? Amanda, maybe you've had to do some reports to elected officials.
Yeah, it is constant of trying to demonstrate value back to elected officials of why they should make this investment into property maintenance. And it's really difficult in places that I work that have, I can't overstate the difficulty that lack of resources has on this conversation. These towns are just so limited financially. And so it's us trying to convince them of why this is a good strategic investment for their community. But I think that going back to that financial impact of blight study that we did when we were trying to get the land bank started and get a code enforcement initiative started, like having that data, it's the cost of doing nothing. Like, what's the cost of doing nothing? I say it's greater than making these strategic investments, especially over time. I hope that helps.
Mhm. Yeah, my only experience in terms of the landlords having some clout uh, with the justice system and with the legislative system, it goes back some years. Greensboro, North Carolina had a proactive rental inspection program that was doing very, very well. And the landlords actually went to the state legislature and got a law passed to abolish their program and to abolish it statewide. And then, like 10 years later, it was some elected officials in the state legislature who themselves are landlords actually introduced a law to reverse that because over time they saw properties becoming blighted as a result of people jurisdictions not being proactive. Let's see, Philip, please explain why more tenants with lead poisoned children do not sue or win judgments against landlords.
I'll take that. Number one is access to counsel. You either will have a housing case or a personal injury case, sometimes both. For example, in the city of Pittsburgh, we just recently got a right to counsel, which is absolutely fantastic, but it's only in specific neighborhoods. Additionally, they will typically only assist in that last minute when you're already have an eviction. So proactive assistance is very difficult to receive. And then personal injury, that again is going to require that someone like your child has already been severely exposed, and it will require a personal injury lawyer to take it on. Right now, unfortunately, due to legal cases, that is at a really low level of PI attorneys that are willing to do it. And it's because even if they take on these cases, which Megan mentioned, take for years, the likelihood that they'll get paid is very low because there's often a dispute of whether it's the insurance provider or the landlord who's supposed to pay you out. So long story short, there are very few attorneys who will be willing to take on these cases. And then those of us who are, we are at severe capacity. And so you're often only able to help the families that are most at need, hence ones with eviction. So it really is a structural issue within the legal system of access to attorneys.
That's where I believe partnerships play an important role in that because here in California, we've had some situations where the district attorneys, community prosecutors have gone after some landlords, and it made a big splash in the newspapers and on TV and social media. Same thing with the Oakland city attorneys, they've done that. But it was a result of them working in partnership with environmental health or public health, which provided them with the evidence they needed in order to bring a strong case against the landlord. Uh, you know, uh, Code enforcement cases, repeated code violations from building inspection and code enforcement. All that type of evidence was used. And then that had a ripple effect in terms of pushing some jurisdictions to move towards proactive rental inspection programs, move towards enforcement of the EPA renovation, repair, painting rule, requiring proof of EPA certification when getting a building permit to do work on a pre-78 house. So there's that ripple effect, but it comes from those types of partnerships.
Yeah.
Let's see. There was a question here. If landlords, oh, Donald, if landlords were required to have liability insurance as part of the rental licensing process, could they be held liable if a child has an elevated blood level? Could the tenant sue for damages on behalf of the child, and should they be required? Okay. Yeah, that kind of speaks to some of the cases that I've been involved in where they did sue, and with the help of our environmental health specialist, who was a expert witness at the trial, well, one family ended up winning a case of got over $1 million.
Mhm.
Let's see, we're pretty good on time. We got 5 minutes left. Anybody got some other questions?
I'll also add some happy notes to the conversation, which are because of how overwhelming the problems are, we are trying to also build proactively those partnerships that you talked about, Larry. So, for example, there is a group within Pittsburgh called the Housing Justice Table, which is just really a coalition of various community members and organizations that are trying to support policy changes and talk to local leaders. We often find that they're unaware of a lot of the severity of the issues, especially when it comes to retaliation. Does this happen here? What is it like? So sharing stories, I think, really does help talk to our local leaders, and we are seeing changes. Despite legal barriers, we have seen our leaders step up to try to enact a rental registry. So I think there's an appetite for some change. Um, as well as to build up those partnerships in the legal space. Our law firm is trying to build resources to provide referrals to personal injury attorneys and build relationships in that space. Because there are some personal injury attorneys out there who might want to do the right thing but aren't familiar with lead law or how to take on the cases. So we're trying to build out the resources to provide them with that. So there are a lot of good things in the works, but of course, that takes time, and there are still uh, um, a lot of people that need to be at the table to make it happen.
Excellent. Let's see. We're just about out of time here. Just 3 minutes left. Michelle asked at the very beginning of the summit, what animal described your energy levels? And I said a puppy, because when it comes to this topic, I'm like a puppy. I just want to run around and chew and gnaw and get into everything and mix it up with everyone. So this has been great for me. I've learned a lot from the three of you. Like I said, I did research on you before I was asked to, come in and do today's moderation. And yeah, reached out to you on LinkedIn and all that good stuff, because you guys are doing some wonderful work. And I hope that our attendees got as much out of this panel as I did. So I just want to give you, Brooke, Amanda, and Megan, a round of applause. Thank you